Welcome back to Arc El Paso, everybody. Now it is time for our weekly segment, Legal Jargon, where we get some of our law questions in our head answered by Daniela Labinoti, an attorney herself. So thank you for joining us, Daniela. And this week we are, so with the holidays coming up, a lot of different food is a big part of the holidays. I'm gonna go to my grandma's house and get all sorts of different kind of food. So basically, if we somehow, me and my family, if we somehow get food poisoning due to maybe some bad food from one of the companies that we use for our holiday meals, can we sue? Can we sue the food company?
Yes, absolutely. I mean, that is a negligence claim or a product liability claim. You can sue the company, the restaurant who distributed the food, the distributor, the manufacturer if it's something that was in a bag. Obviously, it depends on the seriousness of the injury, but in terms of do you have a claim, absolutely. And we have handled some of these claims. The key proof is that if you have to have medical documentation that the whatever condition you received with regard to the food poisoning, or that you had to go to the ER, or whatever happened to you was directly as a result of the food you ate or the bacteria that was inside the food. But absolutely, you can file a lawsuit. So you're gonna need some sort of food receipt, that you were at the store. You need proof of that you ate the food, that you purchased the product, and the medical evidence, meaning that you went to a hospital, urgent care, and you had a doctor document that food or the product you inhaled or ate resulted in harm, meaning a medical condition such as food poisoning or any other condition. So yes.
Okay, but that doctor does kind of have to say that food was the reason why.
Right, that it was as a result of the food, right?
Okay, but this also, you mentioned it, it also applies to restaurants, right?
Absolutely, restaurants, any sort of businesses that distribute food or sell food. Because think about it, let's say you went to a restaurant, you ate food, but then you end up to the hospital because of pancreatitis, because of something else, maybe because you're on Ozempic. And then you're I got sick because of the food. Well, no, you got sick because you've been on Ozempic. So you have to show causation, meaning that you prove that it was as a result of what you ate. So, yes.
Okay, and then what you could get, they could pay for your hospital bills.
You can pay for the hospital bills if you miss work, if that resulted in any other medical conditions or damage to any of your organs. So yes, it just depends on the harm.
Okay, there's plenty of ways you can get paid back for that. Okay.
Right. It's not about paying back. It's about being compensated for the harm, whether it is medical, whether it is pain and suffering, injury, loss of wages. Okay. It's about compensation for harm. It's not about being paid. So.
Okay, you're right. Compensation for harm. My bad. I used the wrong terminology.
Let's use the right label.
Okay, I like that. Thank you for putting me in check. But okay, thank you for answering our question, Daniela. And that is it for this week's edition of Legal Jargon. But make sure you tune back in next week. We do this every week. And stick around on Arc El Paso because we got a lot coming up in the show.